Hi, my name is Srishti.
Hi, I'm Dhriti.
Hi, I'm Swam.
And we're from the team of Lumos Veritas. So, last week we talked about the sedition law. We talked about the meaning of the word sedition, we talked about where the sedition law came from, and we talked about the sedition law in context to legality. So, we're here today with the second video on sedition law, and this video will be more about history and a couple of case studies on the sedition law. So, let's dive into it. The word sedition, as we know it today, first appeared in the Elizabethan times in the 1590s as the notion of inciting, by speech or by writings, disaffection against the state or the constituted authority. The sedition law was extended to all the colonies of the British Empire, including India. So, in India, it was introduced in the year 1870 to control the colonial dissent that was spreading. So, that basically means that the freedom fighters and the natives who were rebelling against the British government. The first known application of the sedition laws in India was against a newspaper editor, Jogendra Chandra Bose, in 1891. Other prominent examples of the application of this law include the trials of Gandhi and Tilak. Apart from this, Jawaharlal Nehru, Abdul Kalam Azad, and Vinayak Damodar Savarkar were also charged with sedition. Before Gandhi, Tilak faced 3 trials in cases related to sedition and was imprisoned twice. He was charged with sedition in 1897 for publishing an article in his weekly publication called Kesari. For this, he was sentenced to 12 months of imprisonment. He was tried again in 1908 and was represented by Muhammad Ali Jinnah, but his application for bail was rejected and he was sentenced to 6 years in prison. Gandhi wrote various articles criticizing the British rule in India. The British government responded to this by charging Gandhi with sedition. Gandhi was tried under the section 124A of the Indian Penal Code for exciting disaffection against the government established by law in India.
Now, coming to more recent times, author Arundhati Roy and politician Hardik Patel made headlines recently. Well, what unites these two personalities? The answer is sedition. Both Roy and Patel have been booked under this section. Roy for advocating a plebiscite in Kashmir and Patel for his Patidar reservation agitation. Section 124A penalizes the act of exciting disaffection against the government or bringing it into hatred or contempt, and the sentence in conviction of this can be life imprisonment. Strong medicine for mere words, no? Countries which share this law alongside India today are Australia, Canada, Hong Kong, Ireland, Malaysia, New Zealand, Singapore, United Kingdom, United States, Germany, and Spain. Interestingly, in the original Indian Penal Code, drafted back in 1860, sedition didn't even exist. That is why there is an A after section 124, signifying a later amendment. It was incorporated into the code in 1870s as a response to the rising Wahhabi movement.
Initially, the section used the term disaffection, which is interpreted by the colonial judges as acts and speeches that incited disobedience towards the government. However, when British realized that clever Indian nationalists were using this loophole to frame incendiary speeches, which made no mention of the term disobedience, they also added the words hatred and contempt, making this offense one for capturing thought crimes. As many as 47 sedition cases were recorded in 2014 across 9 states by the National Crime Records Bureau. These cases did not involve any violence or incitement of violence. A total of 58 people were arrested, and the government only managed one conviction. Between 2014 and 2019, there have been 326 cases of sedition, and only 6 convictions have been managed. Indeed, sedition has survived numerous attempts to get rid of it, and the chances of Supreme Court overruling a 50-year-old judgment are negligible. Consequently, sedition will probably continue to exist and will remain in the news. And it will be the responsibility of the trial lawyers to demonstrate how frivolous sedition charges are. And it will be upon the lower judiciary to get rid of cases which do not match the standard of incitement that require lawless imminent action by the Supreme Court.
We hope you enjoyed this video and learned something as well. We'd love to hear your feedback, your views, your comments, and your suggestions. Leave your comments down below and don't forget to like and subscribe. We hope to see you again soon. Bye.